Statement instead filing a fresh application for stay of execution on the entire trial. Stay of proceedings on the trial pending say court never share two applications are earlier mo de call
Enra okaya Brana Mr. T all the enwama mienu attitude our court no. Or my court now says say there were some interlocutory issues with the request to admit facts and then the request to inspect about some 9 documents. Those processes mean that are pending. It was suggested the application for review, does not operate as a state. As the rules require, they are filing a formal application for state.
Oh, okay. And meaning say on Tuesday, Nyameya Domna say Moko Quarter, you would bring that to the notice officially of the court and ensure say court ever share the 2 early applications now sana.
Already court cry am my 22nd that's 26th.
26th, which is Tuesday.
No correct. And then you can file the application for stay. The registry of the court my 26th as the return date for the motion. On that day, you will move your application for stay. From there, because already, the application for review, is also fixed for the
28th, yes.
Thursday. So within Tuesday and Thursday, from our side, these are the 2 pending applications.
Oh, okay. But what was it? A witness statement, no, na I am ordained, and now say you think, say, in the interest of fair trial and due process, no, was a court, no, hears motions, now, son, ampo, my witness statement,
Okay, and there was some exchange between my lord, Justice Mahama, and Mr. T.
Yes.
Emma, next suggestion, so, Mr. T, the request to admit facts and the request to inspect documents. Say later, if it is done, we can at that point incorporate into whatever proceedings that would have gotten. Mr. T. Emma that's the more reason why this housekeeping should be done before the actual hearing. Because the motion for review requires the Yadinipa Yenubabeka 7 na time for anything can happen. In the event the application for review is granted, what it means is that the 12 questions would have to be served on the electoral commission. Now, if you serve the 12 questions, the answers to this question may even limit the witnesses krana. So the determination of the review application will most definitely have an impact relative to your overall strategy relative to the case. And then they say, once a determination is even made relative to the inspection of documents, your witnesses crana, your the Beba court, no, may be limited. So all this, and that is why what I do know is that using the 2013 petition as a guide, all these matters were taken care of. And so you're moving into the substantive hearing. I've heard suggestions. Sir, CR 99 has come to more or less fast track some of this process. With respect to those views expressed, service. Witness statement, was CR 99. Obi.
Me pass all say.
Me say, witness statements are and court no orders here in file.
Yes.
I was here 99.
No, me share schedule.
It's
maybe.
not there.
Yeah.
Don't worry
Yeah,
yourself.
it's not there.
But court now make it that order no.
Yes.
What is the rule of procedure informing that order? And yet the High Court rules. And yet the amendment to the High Court rules. I introduced a witness statement today into our civil adjudication.
Yes.
So what is the point? Yes, ultimately, we want justice. But like Mr. T. Ekayano, you also do not want a situation where it will look like, in the name of expedition, we have driven somewhere away. You've driven someone away from the throne of justice in the name of expedition. Then we might as well not even litigate. Then the best form of expedition is to dismiss the suit. That's the best form of expedition.
But when you sure lawyer say and I think constantly the court has made it clear say Juma within very strict timelines, which timelines are provided for in CI 99. In 2016, the government then thought it wise to submit before Parliament.
Yes. It has been stated without number that the courts are not slave to the rules of court. The rules of court is basically to provide assistance. The rules of court, they are supposed to provide assistance. The courts have made it very abundantly clear that they are not slaves to the rules of court. In fact, the courts have made it also clear that sometimes, in order to do substantial justice, we must allow A, B, C, D to go through. In any case, OB, petition STC, was yesterday not the third day of the proceedings? Was yesterday not the third day?
Meaning the pre-trial, right?
No. I mean, even the whole process. That was the third day. Or you have been attending other proceedings?
No, I've not had any other proceedings. No.
Yesterday was the third day of the proceedings. So when you say delay, what exactly do you mean?
Okay, maybe just to give you an idea.
I've even heard my colleagues on the other side regrettably make the point. So this is a delay tactic. The rule in the first place even provides 5 days for the pre-trial case management. Sebi, ask any of the lawyers talking that which one of them has done a pre-trial before the Supreme Court in this form. Ask any one of them. In any case, CR 99, this is the first time we are using it. So why are people creating the impression that there is an existing practice that they only know? With respect, I have practiced with most of the people talking
Asempa FM.
at the High Court. I know how they do litigation. So what exactly are they talking about? Which one of them has ever gone for a pre-trial where he didn't have a say relative to what issues should be adopted by the court?
But Sauka say you didn't have a say. Is that factual? Because Muamuka in open court say must submit a memorandum of mu issues to the court.
Relax.
And that's what the court relied on. And
we submitted how many issues? Per the Supreme Court rules, without the amendments relative to 99, the practice is that you file joint memorandum of issues. That's the practice. It is only when parties are unable to file joint memorandum of issues
Asempa FM.
that is when the court will now adopt the respective issues filed by the parties. And now question you why you think this issue should be set from your pleadings. In fact, as for the High Court, when an application for direction is taken, you are permitted the other person to file additional issues. You meet the judge in court, the judge will evaluate, ask you, this issue, does it flow from your pleadings? Yes, of course, no court is bound by the issue set by the parties. But once the parties have come, they must have a say. They must justify why those issues are the issues for trial. Andrea, did you see anything like that happen? Well, the court is to manage, ultimately, its proceedings. That's the overriding essence of the court. If that becomes the case, then there may not be the need for counsel as far as litigation is concerned.
But lawyer, one other thing another person may be sound is say you're caught by the spirit and the letter of CI 99. Now,
the last time when the lawyer suggested the letter and spirit, you remember what?
Now we open up a timelines for determination of presidential petition. Number 1, filing and service. That's duration here for the month of January. 7th day, appearance and answer. 10th day, a pre-trial. 15th day, a hearing. 21st day, a end of hearing. 42nd day, a judgment somewhere in March. So who follows our schedule where lawyer? The 15th day was a hearing starting. In this case, apaho, what really again should the court do? Looking at how tight our schedule way.
No, you will soon be called to the bar. And you notice that when it comes to litigation, rules, like I told you, the courts are not slaves to the rules. There have been several instances where, like I said, the court minded to do substantial justice. We say A, B, C, D, even in terms of compliance. Have you not had situations where the courts have extended time?
Yeah.
You've never heard that before?
Matibida.
Were those rules not set in the rules of procedure? Why did the court extend those times? Because of the overall need to do justice. And Mekaya said, if the whole idea is expedition, then there's nothing more expeditious than dismissing the petition. In limit, immediately. That one, you have done expedition, but would that meet the ends of justice?